Hi, Assalamualaikum and good day everyone. We are from Group 6 and today we are going to present about the contract law. Let me introduce myself first. My name is Nurul Fadila binti Amrin Shukri, metric number 272018. My group members Muhammad Abid bin Jamal Asri, Sadruddin bin Saadun and Nurul Fatin Najah binti Mazlan. For this presentation, I'm going to talk about the introduction and effect of the case, and my group members will continue this presentation about the issue of the contract law, the holding of contract law, next about the rationale of the holding, and the last part is conclusion. Firstly is introduction. What is the contract law? Contract law is the agreement or a bargain that made between two or more persons with strict obligations that are enforceable at law. Other than that, contract law also can be referred to agreement of the parties and the document which express the agreement. Some contract law is not enforceable unless they are in writing and signed, for example, the contract in sales of land. In the contract law, it also have a contract for a hotel. Contract for room between innkeepers and guests must satisfy with the element contractual capacity, maturity, legality, consideration, proper form and also genuine consent. The agreement between hotel and guest can take from many forms which are walk-in, confirmed reservation, guarantee reservation, prepaid reservation, and lastly is blanket reservation. So for today, we are going to talk about the contract law case in the hotel industry, which is the Federal Court in Crystal Crown Hotel case. Service charge cannot be used to pay hotel workers their salaries to meet the employer's statutory obligation to pay minimum wage. On 24 March 2021, the Federal Court in Crystal Crown Hotel and Resort Sdn Bhd, Civil Appeal Number 02-F-4-01 of 2018 ruled that the hoteliers cannot utilize the service charge imposed on bills to customers to meet the statutory minimum wage of their employees. In an effort to elevate the plight of low-income workers, the Parliament has fixed and revised the minimum wage on a national basis applied the National Wage Council Consultative Act 2011 and various minimum wage order from 2012 to 2020. In this case, the hotelier had modified the wage rates of its employees by utilizing the service charge element through the application of the service charge as part of the employee's basic wage so as to meet its statutory obligation to pay the minimum wage. The Federal Court decision, therefore, has a serious impact on the hotel industry, being one of the most significantly impacted industry during the COVID-19 pandemic. This update seeks to provide a brief analysis of the grounds of decision by the Federal Court. Next is background of the fact. The Crystal Crown Hotel Petaling Jaya commenced operation in January 1995 and the employment contract of the employees provided for remuneration which comprised basic salary and service charge. The National Union of Hotel, Bar and Restaurant Workers Union was granted recognition in 1999. In 2011, the union invited the hotel to commence collective bargaining in respect of the term and condition of employment to be contained in the parties' first collective agreement. The hotel refused to do so, and in February 2012, the dispute was then referred to the Industrial Court for adjudication under Section 26(2) of the Industrial Relations Act 1967. That's all from me, and my group members will continue the presentation.
Assalamualaikum, my name is Nurul Fatin Najah binti Mazlan. My metric number is 278341. So I want to present about the issue of the case that we choose, which is related to the Crystal Crown Hotel and Resort Sdn Bhd, who refused to initiate collective bargaining with the union about workers' wage and refused to bargain, which eventually led to a court case. Among the cases that has been discussed in the rationale and concept for the introduction of service charge in the hospitality industry show money quote and deposit in joint account of employee and hotel belonging to eligible hotel staff and payment to employees based on point of service provided in employment contract. Therefore, the court agreed with the MP award that the applicant should not be allowed to fulfill the obligation to pay the minimum wage by using the service paid for by the client. The MP decided that a portion of the salary should be given to the employer in order to be used to pay the employee. The MP acted appropriately in rejecting the applicant's proposal that the service charge be used to meet the minimum wage provided under the law. In addition, the MP decided that a portion of the salary should be given to the employer in order to pay the employee. The MP acted appropriately in rejecting the applicant proposal that the service charge be used to meet the minimum wage provided under the law. After that, MP have rejected the applicant proposal for the employer outside the scope of the respondent representation and not covered by the CA being allowed to share the service charge. If the Member of Parliament complies with it, it will violate of the Industrial Relations Act 1967. The Act as a security officer and secretaries are exempted under the section. In resolving the dispute, the MP has discussed the correct and clear legal principle in the case to be raised in the court. The court was also satisfied that the MP had asked the right question in the making the right decision, as indicated in the award, and had taken into account the relevant matter. Based on the entire evidence, the MP has acted based on jurisdiction and responsibility. There was sufficient evidence to help the MP drop the award, and there was no wrongdoing by the MP. Then the decision of the MP can be said to be irrational and unreasonable to be questioned by the court. That's all for me about the issue of the case. Thank you.
Hello, Assalamualaikum. Okay, I will share about holding of the case. Okay, help. Refusing the player so in terms of included 5-week cost of RM 7,000 ringgit. The court agree with the work made by the industrial court that the applicant could not be permitted to meet its obligation to pay the minimum wage by utilizing the service charge paid by its customer or patrons. In view of the above, the clean wage system proposed by the applicant was rightly rejected by the IC. Okay, the court was satisfied that the IC had asked itself the correct question in making its finding as reflected in the awards and had considered relevant matter. On the totality of the evidence, the IC had acted within its jurisdiction and duties. There was sufficient evidence to assist the IC in handing down the award, and there was no error committed by the IC. Thank you.
Hi, my name is Muhammad Abid and I will be presenting about the rationale of holding. The concept for the introduction of the service charge in the hotel industry shows that the money collected and disposed into the joint amount of the employee. The hotel belongs to the eligible employees of the hotel and the payment to the employees in accordance of the service points allocation is provided in the contract of employment. So the court agreed with the award made by the industrial court that the applicant could not be permitted to meet the obligation to pay the minimum wage by utilizing the service charged by paid by its customer or patrons. So this is meaning the clean wage system proposed by the applicants was rightly rejected by the IC. So continuing the slide, the Court Appeal of Hotel Equatorial Sembilan Berhad by Thomas George M.J. George in Civil Appeal that service charge is the part of wages. The IC, which is the industrial court, decide that a portion of that wage should be given to the employer for the same to be utilized to pay the employees. The IC was justified in rejecting the applicant's proposal for the service charge to be utilized to make up for the minimum wage provided under the law. Continuing applied to the proposal of the applicant for a portion of the service charge to be utilized to supplement the basic wage to meet by RM 900 ringgit. So In the conclusion, based on the foresight of the open of careful consideration of the facts placed by the IC, which is industrial court, the issue that were presented before it as discussed. The IC did not suffer from informative of illegality and irrationality to merit crucial intervention. Brief submission on the issue of cost allow cost of 7,000 ringgit to be awarded to the respondent. That's all for our presentation. Thank you very much for watching.